I don't think we need Gil in here right now.
No.
No, we're gonna take care of Mr. That's gonna be his hearing first. We're gonna have a hearing on Mr. Clayton, so. 18-29699 is now called the State of Texas versus Troy Clayton. That's you, sir? You were here with Mr. Burbank, your attorney, and the state's attorney. Raise your right hand. Do you solemnly swear or affirm any statements you make during this hearing shall be the truth, the whole truth, and nothing but the truth? So help you God, sir.
Yes, sir.
All right, lower your hand. Does the defendant waive a formal reading of this motion to revoke unadjudicated probation? Can we proceed in summary?
He does, and you may, Your Honor.
In summary, this motion to revoke unadjudicated probation, which was filed September 25th of this year, states that on April 22nd, 2019, you were placed on deferred or unadjudicated probation for 10 years for the offense of violating a bond or protective order. Stand by. A third-degree felony pursuant to section 25.07 of the Texas Code of Criminal Procedure, Texas Penal Code. This is a violation of protective order. Under Title VI, offenses against the family, Chapter 24, offenses against the family under the Texas Penal Code. Is all of that true so far?
Yes, Your Honor.
That you were put on probation for that on April 22nd, 2019 in this court, and it was 10 years deferred or unadjudicated probation. Okay, just so you know where, and I'm sure you know this, but I'm just going to remind you. Number one violation states you committed the offense of aggravated assault with a deadly weapon on or about May 21st, 2023 in Jefferson County, Texas. And is that true or untrue?
True.
I mean, what?
Not true, Your Honor.
Okay.
Not true.
Okay. You can get help from him, but I need you to speak
Yes,
on this. 2, you failed to provide verification of performing community service hours as required in violation of your probation order.
True.
Untrue. 3, you failed to provide verification of entering and successfully completing the moral reclamation therapy program in violation of your probation order. True or untrue?
True.
Untrue. That's good. And it's failure to pay court assessed fees, and you're $162 in arrears. I would not send anybody to prison for that. So let's just deal with these 3. He's pleaded untrue. The state may go forward.
Jasmine Dunes.
I'm sorry, who?
Jasmine. Dunes.
Come forward, please, and I'll swear you in. Thank you. And raise your right hand, please. Do you solemnly swear or affirm that the testimony that you are about to give shall be the truth, the whole truth, and nothing but the truth? So help you God. Please have a seat. Thank you.
State your name for the record.
Jasmine Jones,
And how are you currently employed?
peace officer with the police department.
And is that as a certified peace officer?
Yes, sir.
How long have you been employed there?
Almost 2 years.
Were you employed in that capacity back on May 21st, 2023?
Yes, sir.
And did you receive a dispatch or call out?
I did.
And where to and what was it for?
I was dispatched in May 21st to the Southeast Medical Center, approximately behind the Heart Center, in reference to a criminal mission.
Southeast Texas Medical Center?
Yes.
Is that located on Jimmy Johnson Boulevard,
In medical center, right? Yes, sir.
right here in Jefferson County, Texas?
Yes,
Right? Okay. What'd you see when you arrived on the scene?
When I arrived on scene, I saw Ms. Clayton standing by her car in tears, visibly upset.
And did you see Miss Clayton here today?
Yes, yes, sir.
And is she outside of the courtroom?
Yes, sir.
Yeah, you recognized her from before?
Yes, sir.
Okay, so you started visiting with her. Was there anybody with her?
Not at the moment, sir.
When you said she appeared visibly upset?
Yes, sir.
And did she volunteer something to you immediately whenever she appeared to be visibly distraught?
She spoke that.
Your Honor, objection, sir.
I'm laying the groundwork, Your Honor, that it's an exception, an excited utterance under 803.
Overrule.
All right, so what did she tell you?
She said that.
I'll let
going
him
to kill
prove it, see if he can meet the elements, and then I will make a finding on whether it's admissible at this time.
My only
I mean,
objection-
I'm not going to send the jury out and have a hearing outside their presence. I've got to make a ruling on it for admissibility. So I've got to be present. I'm the fact finder, and your objection is overruled, but it's noted. And go ahead.
Let me reword my question. So when you got there, I believe you've already said that she appeared visibly distraught. Is that yes?
Yes, sir.
Okay, so what were some of the indicators that she was working under some kind of emotional
She was
distress?
crying and,
Did she,
okay.
did she seem like she was shaking?
Yes, sir.
And did she, without telling me what she said, did the phrase that she told you, would that generate fear with most people?
Yes, sir.
Did it confirm some of the things that you'd already seen whenever you were talking to her?
Yes, sir.
And is it apparent from what you saw that day that she was giving you something based upon her present sense as far as what took place in the situation?
Yes, sir.
I know it's kind of a wordy situation, but basically what I'm trying to understand from you, ma'am, is if it appeared from your training and experience that the statement she gave came out of some kind of emotional experience.
Yes, sir.
I did ask you, and I want to make sure that, did she volunteer that without you asking anything?
Yes, sir.
So it was just something she immediately stated whenever she saw you.
Yes.
Did she appear to be under the stress of some event that occurred before you got there?
Yes.
And did it appear that that statement came from that event as well?
Yes.
Your Honor, I would submit that meets the grounds for the exception under 803(1) and 2. If I may, I'd like to ask what the statement was.
Your Honor, again, I'm going to object. This is after the fact. Police were called. The police were called out for criminal mischief and nothing else. That was her.
Excited utterance, a statement relating to a startling event or condition made while the declarant was under the stress of excitement that it caused, that is admissible if the circumstances exist. A statement describing or explaining an event or condition made while or immediately after the declarant perceived it, that's present sense impression. The court, though, has not heard exactly how long time had elapsed between the alleged event and the time that this witness arrived at the scene to speak to the declarant.
And in addition, Judge, they've already ascertained or stated that the declarant is present, sitting outside here ready to testify.
I know. So what does that have to do with
Well,
the
because
rule of
they
evidence?
could call her to the stage.
They certainly
and say,
could.
And what did you say?
They certainly could. That doesn't mean just because she's available or not. I'm going to read the way we wrote the rule. I was on this committee, 803. Exception to the rule against hearsay, regardless of whether the declarant is available as a witness or not. That's in the title of the rule. Go ahead. Rule.
So I think I want to clarify one thing for the courts, and that's the timing. Do you remember what time it is that you were dispatched?
I'm unsure.
Do you have your report?
Yes, sir.
Is it in your possession?
Yes, sir.
Would you mind reviewing it and what I'm asking for, ma'am, is I want to address the judge's comment about the timing between when you were dispatched and when she makes this statement to you. Can you tell us what that timing was?
2 minutes.
So 2 minutes from your dispatch to when she makes the statement.
Correct.
All right. So what did she tell you?
She told me she had left for lunch, approximately for lunch.
You know, again, that's not an excited utterance. I've left for lunch.
And defense counsel's right. The question I want you to address right here, right now is what statement did she blurt out to you when you first got there before you even really got to ask her anything?
He's going to kill me.
Those were her exact words, right? So at that point in
Hold
time, did you?
Hold on. She gets a chance to answer.
I'm
You
sorry, I
said-
thought she did.
I didn't hear an answer.
He's going to kill me.
I know. And you said something and I didn't hear the answer to that last question.
I didn't think I finished asking that question to her.
Oh, you didn't? Oh.
All right, so when she said he's going to kill him, did you, in your mind, did you start to investigate that particular incident?
Yes.
What did you see that may have supported that particular suggestion?
I seen her window shattered,
And is that to her car?
so the driver's side window.
Okay, may I approach the witness?
Yes.
I'll show you what I've marked as state's exhibits 1, 2, 3, and 4. My question is, do these pictures truly and accurately depict what you saw when you arrived there on the scene?
Yes,
Is that the car that you were just mentioning to the judge?
yes,
Does it depict information that will help clarify what we're testifying to as far as what you saw that day?
yes,
Those were taken that day,
yes,
not by you, but by another officer, is that right?
yes,
But they truly and accurately depict what they purport to, right?
yes.
No changes or additions to any of these, is that correct?
Sir.
Nobody's changed anything.
No, sir.
Other than the markings there for the exhibits, right?
Yes, sir.
Or we would tender states exhibits 1, 2, 3, and 4.
I've seen them, Judge, no objection. States.
They're admitted.
All right, so what do we see in states exhibit 1?
It's the front view of the car with the damages to the driver's side window, partially rolled down.
And can you identify that car by the license plate from here?
Robert Zebra,
Do we see that same in states exhibit 2?
yes,
And that's from the back of the vehicle, is it not?
yes,
Does it also show the damage?
yes,
Now, without going into what she says, do those pictures depict what she claimed happened that day?
yes.
Specifically, what do we see in states exhibit 3 and 4?
The shattered window with pieces of glass inside.
Did the victim, Danielle Clayton, did she tell you that someone did that to her?
Yes,
Did she go into some detail about those things?
yes,
Of course, she's here to testify about that. But is that why you were taking these photographs?
yes.
Now, officer, from your experience, is this something that happens naturally to a vehicle?
No,
In your experience and training, how does a vehicle end up looking like that, the windows on states 3 and 4?
with some sort of force,
What kind of force?
unnatural force.
Does it require somebody hitting that or with a, can it be done with a fist?
I'm sorry, with a fist?
Yes.
Yes,
Can it be done with a gun?
yes,
Can it be done with other objects?
yes.
What method did Ms. Clayton tell you was used to cause that?
A butt of a firearm.
Did you start then looking for other evidence that indicated that that was true?
Yes,
You were searching for what?
I was searching for the point of force to the window.
Did you see anything to indicate that that force to that vehicle occurred from the inside as opposed to the outside?
Yes. The shatterings were inside the car.
Did you see any shatterings on the outside?
I'm not sure.
But you did see some on the inside.
Yes,
Did that confirm what the witness was telling you?
yes,
Did Ms. Clayton tell you where she worked?
yes,
Does that fit with the location where this work
Yes.
was? Did she appear to be frightened and in fear of her life?
yes.
Did any other witnesses come forward?
No,
So no other witnesses were on the scene, is that right?
no,
Did you make a determination as to whether or not Ms. Clayton had a protective order?
yes.
What did you find out?
We contacted dispatch and asked if she had one on file, which she did.
Pardon me?
If she had one on file,
Did she?
yes.
And is that normal whenever y'all are investigating these kind of matters?
Yes, if it's brought to our attention,
Of course. It was, and you confirmed that that existed?
yes.
And who was the person that the protective order was, who was she being protected from?
Mr. Clayton,
You know Mr. Clayton?
I don't,
So you can't identify him if he's sitting here in the
I
photo?
hadn't seen a picture of him, no, sir.
And did you make a determination about what charges to file?
Yes,
What charges did you determine to file?
aggravated assault with a deadly weapon,
And was that based upon statements made by Ms. Clayton that day
yes,
and how that deadly weapon was used?
yes,
Did you attempt to locate Mr. Clayton?
yes.
What efforts did you make to find him?
Several, we had, several officers check locations that were provided by Ms. Clayton.
And why were we doing that?
Speak with him, we had we had a disturbance, and then while investigating the criminal mischief for Ms. Clayton, another call came in about another disturbance in the check on rounds for another address that Mr. Clayton was at.
So while we're investigating what the judge is looking at, you got a call for potentially Mr. Clayton being involved in something else?
He called for a check on rounds, for a disturbance with Ms. Clayton.
Oh, so he called.
Yes,
Did y'all then visit with him about that accusation?
we had another supervisor try to go up to the scene, but he wasn't there.
Is that out of the ordinary if somebody calls if they're not where they are? That's a
Yeah.
bad question, but in my mind, I'm envisioning if I call the police, I'm gonna wait until they get there to respond to them.
Yes,
Is that normally what happens?
yes,
So if an individual calls Is it abnormal that they leave?
It can be.
Is that the extent of what you dealt with on this case, also?
Yes.
That's means.
Good afternoon.
Good afternoon.
Hi,
Well,
got some questions for you. First thing is, you said something that she had a protective order,
yes,
okay? Where did you view that detective order, or protective order,
I didn't view it.
okay? Do you know whether or not that protective order was still enforceable?
She let us know that it was no longer renewable.
You testified that you checked to see whether or not he had a protective order against
Yes.
him.
It's,
Did you check to see whether or not it was enforceable at the time of this incident?
no,
Would it surprise you that it had expired back in 2018, 2019?
it doesn't.
And so he might not have been, Mr. Clayton might not have been under a protective order.
Is that a question?
Yeah. Well, you testified, and the reason, officer, I say that is because you testified that you checked with somebody and he was under a protective order.
So there was a protective.
Okay, well, then are you saying that it was enforced at the time and he shouldn't have been around her?
I can't say, he wasn't on scene.
So you don't know whether or not the order was intact or not, or enforceable at that time or not, correct?
Correct.
Now, you also said that you had another call, and you testified in reference to some call or some disturbance. And the state questioned you about, well, while this was going on, he was in another disturbance. What do you actually know about that?
I wasn't at the disturbance.
Okay, so you weren't even dispatched, right?
No, I was notified.
What was the location of the call that he was, the other person was dispatched to the other office?
It was 5146 Proctor.
Okay, and what area is that? I mean, is that an office or is that a
It's
residence?
it's a residence.
It's a residence. And do you know if they went out there?
Yes,
Okay, and you know anything about that, or you weren't
no,
there?
I wasn't there.
Oh, okay. And you said that it came from a caller saying he was Mr. Clayton?
It was dispatched. Yes.
That said it was Mr. Clayton?
Yeah.
Okay. Did you realize that Mr. Clayton had called the detective later on
No,
and explained what was going on? You don't know anything about that?
no,
One last question. So where you went to or dispatched to, that is where this occurred?
yes,
And are you saying that there was shattering inside or outside of the
inside.
location? Inside?
I viewed glass on the inside.
Okay. And it was your testimony that there'd be many things that could possibly break automobile side window, correct?
Yes,
Could be fist, could be a gun, could be even a little spark plug porcelain. You ever see that happen?
yes,
Where they throw a little spark plug chip?
I have.
Could be anything.
Yes,
And it could be a fist.
it could.
Good. Thank you, officer. That's what.
No further questions.
Can this lady be excused?
Yes, sir.
You are excused, ma'am. Thank you. Next, please.
You do for a living, Miss Clayton.
Pharmacy technician.
Okay, and where at? Getting back on May of this year?
Yes,
How long have you worked there?
about a year and a half now.
So you know what you're here for tonight, right?
Mhm.
Yes.
Yeah.
So whenever you're answering my questions, do me a favor, make sure you speak up. You're being a little soft spoken so far. And please, make sure to give a verbal response, okay?
Yeah.
All right. You live in, Jefferson County?
Yes,
I don't need the address, but you live in Port Arthur, Texas, correct?
correct.
All right. Back in May of 2023, were you married to Troy Clayton?
Yes,
Do you see him here in the courtroom?
yes,
Can you point to him and identify something that he's wearing?
insurance.
You know, the record reflects you identified the defendant, Troy Clayton.
Yes, it will.
How long have you known Mr. Clayton?
Since I was 3 years old.
Since you were 3?
Yes,
I don't like asking a lady how old she is, but it's been more than 30 years, right?
correct.
When did you all get married?
April of 2018.
Are you the complainant for the violation of protective order that this individual is on probation here with court?
Yes.
So you've had a protective order against this, protecting you from this individual in the past?
Yes,
And he has violated that protective order.
Correct.
That's what's resulted in the felony charges.
Yes.
Has he also been accused of assaulting you on multiple occasions?
Yes,
Have you followed through with those charges in the past, ma'am?
no,
Why?
because I believed when he said he would not do it again and tried to move forward and believe that it would get better.
Has it in fact gotten better?
No,
Has it gotten worse?
yes,
This afternoon, when you and I first met, what was your biggest concern, ma'am?
that he's gonna get out and it's gonna happen again.
In fact, has he been trying to communicate with you while he's been in custody?
Yes,
Tell the judge the efforts that he's made to communicate with you about these charges.
I got multiple calls, video calls and notes, emails, whatever they call them.
And that's been since he was arrested on this May 21st, 2023 incident, yes?
Yes,
The nature of those calls or messages or anything, did he threaten you in any fashion?
no,
That you were afraid because of those multiple contacts?
he did not threaten me. He's too smart to threaten me on the phone or anything like that, no. But I know if I would not answer the calls or respond back, it's going to be a problem.
Why do you say that?
Because when I don't answer or while I'm at work or anywhere else where I can't answer the phone, when I finally do talk to him, he's upset.
Is that what happened back on May 21st of this year?
On May 21st of this year, we had argued that morning. And then it just didn't end when I went to work.
No, the exhibits, Judge. You're on. I'm sorry, state that for me one more time, ma'am.
We had already been arguing before I went to work and it didn't end because I went to work. He came to my job to finish the argument.
Is that fairly normal conduct? I know it's not normal conduct. My question is that how he normally handles matters?
Yes,
Did he show up on May 21st, 2023 to finish the argument you guys were having?
yes,
Had you all been separated before this incident?
yes,
And have you been separated since this incident?
yes,
Have you actually started a divorce?
yes,
It's still pending?
yes.
No, Coach.
Yes.
I'm gonna show you what I've already got in the evidence, ma'am, the state's exhibits 1, 2, 3, and 4. You recognize the images here? Is that a yes?
Yes,
Okay, I gotta make sure I get your answers verbally, all right? Is this your car?
yes,
Now, depicted in here, more, a very close example of it in 3 and 4 is a shattered window. Did you do that to your vehicle, ma'am?
no.
All right, I want you to tell the judge how that happened.
Fred broke it while I was sitting inside.
So that he broke it with what?
With the gun bottom, they got it out of the car,
So
out of his trunk.
let's back up to that. I don't want to go step by step. You work at this location, right?
Yes, that's the parking lot.
How is it that you all end up out there in the parking lot?
I had left for lunch to go get something to eat.
Okay,
Went over, got something to eat and I was on my way back to work. I pulled into the parking lot and probably not even 10, 15 seconds later, he pulled on my passenger side, pulled in and parked next to me. I didn't even see where he came from.
it almost sounds like he was either out looking for you or was following you there.
I don't know, I didn't see him follow me.
Okay, but he appeared right as you got there.
Right,
So what,
I hadn't even cut my car off yet.
okay, so what happens next?
He got out the car and went to my passenger side and was tapping on the window and saying something like, I don't know what he was saying. I turned the radio up
Why?
because I didn't want to hear what he was saying. I just wanted him to leave because I'm at my job.
He didn't leave, did he?
No.
What did he do next?
When I turned the music up, he got frustrated and left from that side. And I'm looking at him go to his trunk and he pops the trunk and goes inside. And then he walks around to the driver's side.
So let me stop you. Did you know what he was getting out of that trunk?
No,
Did you know he had something there?
no,
Did you know he had possessed a firearm?
yes.
Okay, so you weren't sure what he was doing, so what does he do after he gets the item out of the trunk?
When I see him walking over to my driver's side, I picked my phone up to call my cousin. Because I was gonna try to get him to calm Joy down because they're friends. Then I looked over and Joy was at my window.
On the driver's side.
Yes, saying something, I don't know, but I have to hold in my hand, and then all I see is this.
And you made a motion like these.
And then it just started banging through the window, like to get through the window to me. So I dropped the phone.
Could you see the gun at that time?
Yes, coming to the window back and forth until it shattered. Then I couldn't see anything else anymore.
Right, I need to back up because I gotta make sure my record's clear. You said you could see something, and ma'am, you did a motion,
Yeah,
you had your hands and you were going back and
Right.
forth. And does that, now looking back, does that indicate that he was trying to, load the gun? Rack the gun, as some people will say?
yes,
And you said he started hitting the window?
yeah, till it shattered. And then I couldn't see him no more or nothing either out that window. So I threw my car into drive because it was still running and went over the curb into the grass, into the median part almost to the driveway.
Did those actions leave you in fear of? Did it put you in fear, ma'am?
I was already in film before that.
Did you think he was gonna try to kill you?
Yes,
And in fact, when the officer got there that responded, did you tell him that specifically?
yes,
So those actions you just described to the court, you felt threatened by that? Yes?
yes,
You were concerned about imminent bodily injury?
yes.
Did you specifically tell the officer that something about the gun and, you thought that the only reason why you were, did you make any statements about the only reason why you thought you were alive?
Because he didn't get it to work correctly.
That was the impression you had.
Yes.
And you told the officer that.
I did,
And at this time, man, y'all were family members, right?
yes,
Married and still married today, but you're
Yeah.
hoping to get divorced, right?
yes,
Did you tell the officer that the gun appeared to be jammed?
yes.
Did that appear to anger Mr. Clayton even more?
He was already angry. He was already angry,
But did that anger him even more?
probably,
You know him, huh?
yes,
And his actions that day, he wasn't being calm, was he?
no,
Describe that gun for the judge, please.
black,
Is it the kind of gun that you knew him to have? Because you told us that he did possess a firearm.
yes,
Your knowledge, did anybody see all these events take place besides you and Mr. Clayton?
yes.
Who else?
His friend that I didn't even know was there until after all this happened.
And who was that?
Derek Evans,
And you later learned he was there
right,
and potentially saw all these things. Is that correct?
correct,
You don't see them here today, do you?
no,
What made him stop his actions that we've described to the judge? Was it you driving off or was it something else?
once I drove over the median, I saw him go, and he passed on the side and got in the car. Cause maybe he thought I was fixing to drive away, I don't know why he stopped and got in the car after that, after I put my car into drive. That's when I noticed his friend standing outside the car, not helping, not doing anything. He was standing outside the car, then he went around and picked him up and then drove off.
Be your out there. But you're concerned about what's gonna be the outcome when it's all said and done.
I know what the outcome is, so
So,
I'm gonna be fighting my whole life with him. That's just how it's gonna be. We've been fighting for 16 years and it's not gonna stop. It's only gonna progress. It's not ending. I'm in a death row sentence.
have you had some peace from this as this man has been in custody?
Yes, I can sleep without thinking about my door getting kicked in or something. Or somebody popping out on me while I'm trying to get to work.
Or anything I haven't covered with you, ma'am, that you need to discuss today? And that's the incident as far as that's concerned. Right?
Right,
And you're gonna help me when it comes down to prosecuting this matter on the indictment that we're not dealing with today.
right,
We're just dealing with motion to revoke probation.
correct.
You're gonna come back and
Yes.
help me when this rolls around, yes, ma'am?
Yes.
Absolutely.
Afternoon, Ms. Clayton. Have some questions for you, okay? When did they arrest Troy? You know what date it was after this incident?
No, I don't remember.
Was it not too long after?
I think like a month or so after.
Did you all still living together, after that, or
No,
did you stay together?
no,
But you all talked,
yes,
and you talked about what happened, right?
a little.
And he fixed your damage,
He sent me an Apple Pay to fix the damage he did.
right, but he paid for the damage, you accepted it, right?
Correct.
Since he's been in jail, have you had communications with him?
Yes,
And in fact, you've given him money in jail, right?
yes,
Now, this is you being on a death row or death, whatever it is that you just testified to.
correct.
You're still, and he's locked up in stripes,
Mhm.
and you're still communicating with him and providing him funds.
Correct.
In fact, didn't you come to my office?
No, I didn't.
Well, did you call?
No, I found out there was another female he's been calling on three-way to your office with pretending to be me.
Oh, okay. And who would that have been?
A woman named Kathy.
So you never called my office?
I have called your office on my own.
Okay. Is your telephone number 409-021?
Yes,
And did you tell the people in my office that you were the wife of Troy?
yes,
Why would you have called my office, in the first place?
to see if his court date had changed. That was my question.
And did we answer your questions?
Yes,
Why didn't you call the district attorney's office about the court date?
he asked me to call you.
Huh?
Troy asked me to call you. He gave me your phone number and your name because I didn't know it.
And it was just to ask when the court date was?
He also wanted me to sign a non-prosecution affidavit.
Okay.
He asked me to sign that and to send it to your office that you were gonna be waiting for it.
Okay. So he asked you to do that?
Yes.
And you called my office?
Right.
Okay. How many times have you placed money in his books?
Probably like 3 times. And then I also did e-com because he said he was hungry. So I did that as well,
How many times did you do that?
probably 3 or 4 times.
Now, you understand, Ms. Clayton, that you said he stuck a gun, he
Mhm.
broke your window, you felt threatened
Right.
and going on, and it'll never stop, and you're continually communicating.
Right. So with the communication, I blocked him and he called me through three-way with other people. And so I was told to unblock. So I unblocked him and then I let the calls come through again because he was getting in contact with me anyway through three-way calling. And it says that that's not allowed, but it's allowed because it happened constantly.
But Ms. Clayton, the point being is not only are you communicating with them, I guess voluntarily, you're also providing funds for them at least 7, 8 times.
Mhm.
That's crazy.
It is
Objection to
crazy.
that sidebar.
Sustained. Sustained. Let's see what her answer is before you act as a psychologist or psychiatrist. Maybe she has an explanation for it, but
Yes,
it wasn't a question. It was a comment, and that's disregarded by the court. Go ahead.
because if I don't, when he gets out,
Okay.
I have to answer for that, and none of y'all are gonna be there when he comes to tell me, you left me in there hungry, you left me in there with no soap, like you said, and you didn't answer my call, so what were you doing? Because if you go back and listen to the calls, I've already been questioned when I didn't do it, so I have to, until I know that he can't get to me. Because when he walks out of here, it's me he coming to see, not you. So I have to explain why I wasn't doing that stuff.
You've been together or you've known each other since you were 3 years old. The state said over 30 years. You've been married for how long?
5 years,
How long have you all lived together prior to the 5 years?
on and off for about 15 years.
When are you going to get the message, if that's the way you feel, that you need to stay away from them or move?
I got the message, that's why I'm here for the first time ever in 15 years.
15 years.
Yes,
And you sure you had a gun?
I'm positive.
Nothing further, Judge.
I have no further questions for this witness, Judge. Your Honor.
Don't shake your head or nod your. I'm watching you. Don't lie to this court. You're trying to send some kind of communication for her responses. You'll get a chance, but don't be nodding or shaking your head after she responds. That's forbidden in courts, and we all know that. Everybody knows that. A defendant cannot do that, nor anyone else. try to make communications, which is what you do when you're, what I'm doing to you.
Yes.
Doesn't help you at all after what we are hearing.
Yes.
That doesn't help you. Anything else?
I'm done. I think she'd be excused.
Raise your right hand. You solemnly swear or affirm that the testimony you are about to give shall be the truth, the whole truth, and nothing but the truth, so help you God. Is that a scene? Thank you.
Sorry. First off, I apologize. We don't call people by their title. We call them by their name. So let's get that clear and state your name for the record, sir.
Alex Hill,
And how are you employed, sir?
I work with Jefferson County Adult Probation.
In what capacity?
I was community supervision officer
And how long have you been employed with our department, sir?
since March.
And as a part of that, were you assigned a defendant by the name of Troy Simon Clayton?
Yes, sir, I was.
And was that over cause number 18-29699, a violation of protective order?
Yes, sir.
You see that individual in the courtroom here today?
Yes, sir.
Would you point to him and identify something that he's wearing?
Yes, sir. He's the gentleman in the black and white striped uniform.
All right, sir, I want to talk to you about the administrative matters that he's entered pleas of not true to in this motion. They are counts 2, which is about community service hours, and count 3, which is about the moral recognition therapy.
Yes, sir.
Number 1, in regards to the community service hours, did Mr. Clayton fail to provide verification of doing those hours?
Mr. Clayton has completed 100 of the required 500 hours.
So the accusation is that he failed to provide verification. Is that true or not?
He has failed to provide verification on completing all 500 hours.
So it's kind of, I may be mincing words. He's done some, but not all the hours.
Correct.
When he's done them, has he provided you proof about the hours?
Yes, sir, yes.
Was he supposed to have had more done by the time we filed this motion to revoke probation?
I can read you the exact court order if you want me to.
Does the court order say that he was supposed to have done a minimum of 50% within the first year?
Yes, sir.
And he was placed on this probation back on April 22nd, 2019, correct?
Yes, sir.
I'm going to object to that question because the allegation is he failed to verify community service hours verification. Not that he didn't complete the prerequisite number of hours during a period of time.
Overrule. Everything about the defendant while under this court's watch that has something to do with the condition of probation, the court is willing to consider.
Well, for the record, Judge, the allegation that was presented was he failed to verify it. And the probation officer says that he did verify the community service hours that he did. The allegation wasn't that he failed to do the prerequisite community service hours.
Actually, the specific accusation is that he failed to provide verification performing the community service hours required.
That's verbatim from
Still object.
allegation 2. Overrule.
So to get to the meat of the matter, if he'd have done what he was supposed to do, he should have completed 300 hours in the first year.
250, yes, sir.
250.
It was 500 hours.
Okay, so the motion claimed that it was 600 hours. Your document.
Oh, I apologize. It was 600 hours.
Okay, so my motion's right at
Yes, sir,
600,
600 hours.
and that means that by April of 2020, he was supposed to have done 300 hours.
Correct.
And to date, you've only received proof that he's done 100.
Yes, sir.
Is that an accurate statement?
Yes, sir, that is.
When's the last time that he performed the community service hour?
The last time Mr. Clayton provided documentation of completing community service hours was December 14th of 2022.
So there was a good solid 5 months between his last verification and when this new offense is alleged.
Yes, sir.
All right, let's shift gears then to the moral recognition therapy program. The wording here in the motion says that he failed to provide verification of entering and successfully completing that program.
Yes, sir, that's right.
Did he enter it?
No, sir.
So he never entered it.
No, sir.
When was he supposed to do that?
Typically, those courses are completed within the first year of supervision.
Is there some exception that's been made in your file that indicates that was waived for him?
Not that I know of. Sir.
Were there excuses offered as to why he didn't do this program?
No, sir.
So as we sit here today, he's failed to provide verification of entering and successfully completing that program.
Yes, sir.
I know the court knows the benefit of this program, but what is it, so that the record's clear? What's the purpose for that program?
It's a cognitive course. It's supposed to teach valuable life skills such as like coping mechanisms with anger, those type of things.
Kind of like what you sat in here and heard happen to Ms. Clayton, right?
Exactly.
So we can hopefully avoid those scenarios.
Yes.
All right, so you basically picked this up, you said in March, if I remember right?
Yes,
And you end up moving forward with this administrative hearing on July 21st of 2023.
correct.
As the witness as to these accusations.
Good afternoon, Michelle.
How are you?
Doing good. How you been? In your records, do you have anywhere where he has attended anger management?
Yes, sir.
And you said part of the coping mechanism for the MRT program was coping with anger.
Yes, sir.
And so did he go through the anger management program?
Yes, sir. He completed anger management online.
Okay, and do you know what date he did that?
I have the certificate. I have a certificate provided by excuse me, saying they completed an 8-hour anger management course online on January 15th, 2023.
When?
January 15th, 2023.
And is that part of this program?
No, sir, that's a separate condition in the school.
So why would he have, was he ordered to do anger management?
Yes, sir. it was.
Okay, in addition to this?
Yes, sir, in addition.
Now, he started probation in 19,
Yes, sir.
when in 19, at the end or the beginning?
He started probation on April 22nd of 2019.
And do you know whether or not COVID had anything to do with this?
No, sir, I'm not aware. I wasn't employed with the county at that time.
COVID started when, early 20 or was it 2019?
March 20,
March.
about March 20.
March 20, so he would have just been in his first year when basically everything shut down, correct? And that could have been for a year, year and a half, correct? So now, do you know whether or not during that period of time, they were holding these classes?
Oh, no, sir, I'm not aware.
Common sense might tell you that they kind of suspended everything until it all quit. Common sense.
Yeah.
Yeah, I mean, but right after he did do, was that at your direction going to anger management?
It was under the course directions. It's in.
Fine.
You took over his probation in March of this year,
Yes, sir.
and how many times did you actually see him?
Possibly 2 or 3 times.
And were those set visits?
Yes, sir. It was scheduled.
And did he come to the visits that you set up?
Yes, he attended visits.
And when he got there, what did you discuss, or were there any problems that you were discussing?
Any outstanding conditions, like the moral recognition therapy, that was an outstanding condition. PD's community service.
Let's talk about the MRT.
Yes, sir.
Okay, what did you tell him in reference to not going there?
That in his case is quite dated. That's typically a course that's required to be completed within the first year. And then you have to.
Did you ever think about filing a motion to revoke before this incident, which occurred, I believe, in May?
No, sir.
Prior to the May 21st of this incident, the new offense, that you were going to file a motion to revoke because he didn't complete.
No, sir. I was willing to work in this department.
So he was working,
As far as I'm, yes, sir.
respectful to you,
Yes, sir.
and did what you said to do, except for the class.
Correct.
Did you ever address the community service hours, saying, hey, you're kind of behind on the community service hours, what's going on?
Yes, I did.
And what was his response?
He was employed, he was working, it was difficult to make arrangements to participate in community service. I just advised him that it's a requirement of the court and he needs to make every effort possible to complete those.
Do you have recorded where he was working at the time, or was it a job that probably you had a problem doing community service, or do you know?
He stated that he was working large amounts of hours and it was gonna be difficult.
Do you know where he was working?
It would be in our system. I don't have it in my file here.
Did you ever give him the option of possibly paying for the community service instead?
Yes, sir. I always advise my clients if they're current on their fees, which is part of the condition with purchasing community service hours, that he's more than welcome to do that.
And we see here that he was behind about $160.
Yes, sir. At the time this.
So he was kind of current, wasn't
Yes, sir.
he? And so he would have been eligible for a lease purchase.
As soon as he hits that 0 delinquency. Yes, sir.
That's what, thanks, sir.
Yes, sir.
No further questions.
Can this man be excused?
Yeah.
Or stand by?
Stand.
You are released from the stand at this time. Thank you, sir.
Stay rested.
Call Mr. Payton.
Come forward. You already been sworn in? We already said at the beginning, didn't we?
Yes, sir.
Because I normally do that at the beginning, for the defendants. You're still under oath, sir. Go ahead.
Ms. Clark, for the record, to state your name, please.
For Simon Clayton.
And Mr. Clayton, you were one and the same that was placed on probation back in 2019
Yes, sir.
for the offensive violation of protective order.
Yes, sir.
The protective order, has it expired?
Yes, sir.
And when did it expire?
It expired in September 2018.
Okay. And during that time, you married Mrs. Clayton,
Yes, sir.
Daniela?
Yeah, we actually got married on protection order in April 28, 2018.
When did you all stop living together, as husband and wife, or separate?
Actually, the day that the incident happened,
This is May 21st.
May 21st, we had got evicted out of the apartment complex that we was living in. And I was already working on a house that I had received from my mom. My mom passed away. I inherited the house. So
Let's stop right there. You were evicted from the apartment complex that you were living in?
yes,
What was the name of that apartment complex?
the name of the apartments was South 25th Street. I can't remember the exact name, but we just had got evicted.
Were you working at the time?
Yes, I was.
Where were you working at?
USA the bus.
Okay, and where did you work at?
I'm a catalyst, handler and welder.
No paddle and welder?
Yes,
And was that a full-time job?
yes.
What were your hours usually?
I would work 7/12s with them, and most of the time, a lot of my jobs is not even in time. A lot of my jobs are out of town. It's very rare that I would even have a job be in time.
Let's talk about May 25th. We want to talk about it.
Yes.
That day or that morning, were you working?
No, I was actually off that day due to the fact of the situation that we had just been evicted from the apartment like 2 or 3 days prior to that. And I was getting hotel rooms actually. Me and my wife was both staying.
Danielle?
Yeah, Danielle was staying at the same hotel room.
What hotel was that?
One of the hotel rooms was the America's Best Value Inn, right there off of Memorial, right down the street.
So what happened that morning?
That Saturday night, me and her was both separate from the hotel at the time, but then I think about 1 or 2 o'clock, something like that morning, we was both there. Actually, I was there before her, because my son was at the hotel room with me. And she came, and me and her, we was having arguments then, but then we fell asleep, woke up that morning, she had to be at work at 6:30.
Okay.
We went outside, I was talking to her about it, I was asking her questions like, how did you let us get evicted out of our apartment if I've been sending you money to pay for the apartment?
Now, she left for work?
Yeah, she was leaving for work at 6:30. She had to be to work. This was around like 6 o'clock.
Okay.
So
This incident happened about 11:30.
yeah, the incident with yes, it happened at 11:30.
So what happened that caused you, or whatever happened at 11 o'clock?
We had been on the phone back and forth because that morning I dropped my son off to her mother's house and I picked up her uncle. Her uncle was at her mother's house, which he was the one who was working on my mother's house. So we had been back and forth on the phone, arguing and texting, and I'm like, what happened to all the money? Because from what the people said at the apartment complex was that
Objection, he's going into hearsay response to.
Sustain.
Was money missing that you couldn't account for?
yes,
And did you wanted answers?
I wanted answers about
Okay,
money.
so what happened to culminate to the 11:30 incident?
Well, I had to go get a port for the house in Lowe's, and I knew she was gonna be on her lunch break. So I went up there, I knocked on the window.
And when you went up there, what did you see?
She was parked in a regular parking spot. I walked over there, I knocked on the window, talked to her about like what happened.
Were you upset?
I was upset at the time.
Okay, and so what happened when you knocked on the window and you were upset?
She looked at me and asked me what was I doing there, and I said, I'm coming to talk to you about what's going on, like
What do you mean, what's going on?
what happened to the money.
Okay, and what was her response when you told her that we needed to talk about what happened to the money?
She looked at me, rolled her eyes, she turned up the music in her car, she started texting on her phone. Basically,
So how did that make you feel?
I was upset.
Okay, so when you got upset, she turned up the music, took the phone out, started texting, what did you do?
I walked to the drop side of the window. I knocked on the window. I asked her like, what's going on? Why you acting like this? And
Did she respond to you?
she was just like, you came up to my job. You came up to my job.
Okay, so what happened next?
After that, I hit the window. I been upset, like I stated to the police officer. I hit the window and the window did shatter
Where'd you hit the window?
with my fist.
Did you hit it one time or several times?
I hit the window one time.
And, you broke the window. Did you ever go to your car to get a gun?
No, I never went to my car and got a gun or anything like that.
You ever have a gun in your car?
I never had a gun in my car.
After you broke the window, what did you do?
After I broke the window,
You shot it, didn't break the pieces.
once the window shattered, I got in my car, she backed up, and I thought that she was gonna try to actually drive and try to hit my car when she jumped the curb, 'cause my car was right there. She jumped over the curb, swerved around. I got in my car and I left.
After you left, did you go to a location and call the police?
Once I had left from there, I didn't go straight home, but I was like, well, you know, by the window being being shattered on my car, that she probably tried to come by my house or the house or do something like that. I called the police and I asked them to do a check. Then when I got a call back,
Okay, so what house were you gonna go check when you just got evicted from your apartment?
5140,
Whose house was that?
that's my house.
That was your house. That was the one you got from your mom? or your
Yes.
family? Okay. And you just called to ask to do a welfare check?
Yes.
Is that where you thought you might have been going?
I mean, at the time, we both was angry and upset. I just wanted to make sure that none of my windows or anything like that or happened to the house, because I was working on the house.
Has she damaged stuff before?
Yes,
You were contacted by the police or did you contact the police?
the officer, the detective said he was gonna meet me. He never came. Then the next day he came.
Okay, and did you talk to the officer?
Yes,
And did you tell him exactly what you testified in court today?
yes, I told him, I said, you know, our emotions ran high. We had been arguing. I did break the window. I admitted to breaking the window. I punched it with my fist. He took pictures of my hand
Right?
and I showed it.
And so he took pictures of, so somewhere the police department has pictures of the hand.
Yes,
Did it have bruising and cuts on it?
yes. I still have scars on the top of my hand, on my hand right here.
So they took pictures of it.
Yes.
Did you, in fact, get the window repaired?
Yes, I sent a message to my wife. I told her, I said, you know, that I was upset at the time about the situation. I was arguing, and I should have never, you know, got that mad or upset that I was wrong about that, and I didn't mean to, you know, punch a window. And I sent her $329.
You've heard Daniela talk about the number of years you've all known each other, the number of years that you've been dating and being married in reference to things that have been going on in reference between the two of you.
Yes,
Been an up and down relationship.
yes.
Why are you sticking around? Why did you stay there with her when you knew you were having so much problems?
I stayed because, I mean, at the same reason she said she stayed, I thought the situation was gonna actually get better. We had a son together.
Well, hold on.
Mhm.
Actually get better.
Yeah,
Well, she says you're the aggressor.
I'm not the aggressor. I mean, even though it seems that way, but I'm not the aggressor. They have police reports from Groves Police when Miss Bigness actually drove a vehicle going to my vehicle.
So you've called the police for what she's done and she's called police on you for what you've done.
Yes,
Again, why didn't you all just separate and just go on your own way? Because here you are in black and white stripes. You say you have a son together.
yes,
How old's your son?
11 years old.
And was that who was staying with you at the, in the hotel?
Yes,
Where's your son now?
he's with her now, staying with her, but before, I mean, the charges came up or anything like that, my son was staying between, you know, with her at her mom's house and staying with me at my house.
Community service hours. That's not the major point in this case. It's the new allegations of aggravated assault with a deadly weapon. But, could you have paid for the community service hours? Or do you
Yes,
know?
yes, I paid for, actually, Mr. Hill wasn't my first officer. I came to this court December 15, 2022 for a review with Miss Chelsea Williams as my officer.
Okay.
At the time, she told me that I needed to complete some community service hours.
Okay.
I had already paid all my fees up to
When
date,
was this in 22?
December 15th,
Was that, so that would have been after COVID, people started getting back into the court again.
yes.
And you were told you had to start your community service hours.
Yeah, when I actually came here, it was for review. I was in this court, Miss Williams at the time stated that I had all my fees paid up. Today, I did the anger management, and actually, she did receive the community service hours. And we sat here and she was stating that she was trying to recommend me for actually to be released off of probation at the time.
So you started doing your community service hours.
Yes.
Okay. Tell us a little bit about the course, the recognition, moral.
At the time, I wasn't aware of the recognition course until I went to see Mr. Hill when Mr. Hill became my officer. I had,
Well, how did you then become, how did you know to do the anger management course?
because Ms. Williams told me that in order for me to get off probation early, that I needed to do the, I think it's an 8-hour anger management course. And then I was asking her, well, what could I go do? She said, well, since COVID, you can do it online.
And you did that.
And I did it online.
Did you do any other courses while you were on probation?
No, because I wasn't even aware of the courses until Mr. Hill got my caseload.
Judge has to decide what to do with you on probation. What do you want, what are you asking the court to do, in reference to this probation? He can sentence you, for a period of time in the penitentiary, up to 10 years. He can extend you on probation or do whatever else he feels just. What do you think is just in this case?
For the motion to revoke probation, I'm asking to actually be reinstated because in December, I was already recommended to be let off probation in the same court. And for the honest,
Now, hold on a minute. Hold on. December, yes, but in May, this happened.
yes.
So what happened between, yeah, I think I'm getting off early in December of 22 and May 21st of 23, you're having a fight with your wife in South.
With the situation with my wife, like I've stated on numerous times, and even when me and her have had conversations after this situation happened, today was not the first time since since this incident happened that I've seen my wife. Me and my wife actually went on a whole trip June 5th to June 9th with my son for his birthday.
23?
No, yes.
Last summer?
Yes.
Where'd y'all go?
We actually went to Circus.
Where was that?
It was in Las Vegas for his birthday. Because due to the time I thought that I was off probation. And we actually went. Not only that, my wife has spent a night at my house. My wife has been to my house. We've talked every day.
When did you go to Las Vegas?
June 9th,
I didn't approve that.
June 5th.
I didn't approve that.
At
I didn't approve that. What else you want to say?
at that time, sir.
You're on your own probation now, right? You're making these terms of probation up?
No, sir.
No, that wasn't with my permission. You're under this court supervision. You act as though you're the one out of the 5,000 people on probation who shouldn't have supervision. You're under your own terms. That's what this is boiling down to.
At the time, sir, when I thought in December that I was let off of probation, that's what I thought when you told me that Ms. Williams told me that I've been through 3 different officers that's been saying, I'm gonna check into it. They checked into it. The paperwork is in. Even Mr. Hill could even state, me and him looked on his computer and it said that Stevens recommended me to be let off of probation. He seen it. We both seen it. I said, well, what's going on?
I want to see that.
Your Honor, he's confused. What he's
Mhm.
referencing is there was a motion to dismiss the motion to revoke probation he had. I'll clarify on cross.
Yeah, I know the way it works. We've only been doing this for 16 years. You're not treated differently than all the others. And what you're telling me is something that's unique just to you. And that's not the way it works. You are treated the same.
I understand that, sir.
You misunderstand at the least. At the worst, you're intentionally defying the court's order.
When were you placed in custody, Mr. McClary?
July 1st.
July 1st? You went on a trip, you weren't supposed to, without permission, but you all went. Were there any problems there?
No,
How many times did you all spend the night together between, let's just say this year, before you were placed in custody?
numerous times, as a matter of fact.
How about after May 21st?
Again, numerous times because, I was arrested July 1st. No, not July 1st. I was arrested July the 12th. Miss Clayton was at my house on July the 8th, 9th, and the 9th. Matter of
8th, 9th, and
the 8th and the 9th. That was the Saturday and Sunday.
you all think that you're kind of like oil and vinegar? You know what that means? Y'all can't get along. You heard what she said.
Yes.
What's your response to it? I mean, she said she doesn't want anything to do with you, and what's your response?
My response to that is, I mean, the divorce come through, I'm gonna go ahead and sign the papers, and obviously get a divorce.
Did you ever force her to be with you?
I never forced her to be with me.
Did you ever tell her that she had to?
I never told her that she had to be with me or anything.
Did she voluntarily let her son, your son, stay with you alone and do things and stay with you overnight?
Yes,
I mean, she didn't say, "Oh, you can't have your son because."
no, she just never did. There's been times, even during this period, that her daughter, which is my stepdaughter, have called me asking for money, have even stayed at my house too.
On the day that this happened, though, you were upset because money was going out of your account and you were trying to get a house so that y'all could live in.
Yes, I was actually working, sending money to make sure that, the bills was paid,
And you realized they weren't.
and I realized they wasn't.
That's what you.
To Defense Counsel States Exhibit number 5, which purports to be the documents from the court's file, inclusive of a motion to dismiss, the motion to revoke probation that was filed on May 7th, 21, and the administrative hearing that supports it. All these documents are documents I could ask the court for judicial notice, but I won't use them for cross-examination purposes.
That's all, Mark. This date, so the 22nd. And then do it 22.
Yeah, okay. No objections to state's 5, Judge.
It's admitted.
All right, Mr. Clayton, let me show you what's marked as State's Exhibit number 5. This is on the front page. It indicates a motion to dismiss, motion to revoke probation. The date is December 15th, 2022. Remember you were telling the court that in December you thought you were getting off probation?
Yeah.
Does that date correspond with the fact that actually what's true is that your MTRP, your motion to revoke probation that you previously had, was being dismissed, so you're being placed back on probation? Does that make sense? All right, let's go to the next page. Is it true, sir, that on May 7th of 2021, you were given a motion to revoke probation for the same matter that we're talking about? Is that true?
Okay.
Let me rephrase that. Is it true that this is your second motion to revoke probation? If I told you that records reflect that your first motion to revoke probation here in State's Exhibit number 5 was dated May 7th, 2021, would you disagree with that? Sir, in this motion to revoke probation, it alleges that you had some problems reporting. So specifically, you didn't report in June 2020, July 2020, December 2020, and April 2021. Is it true that those were the accusations? You had a little problems doing that, right?
Yes.
You also had some problems paying fees. Isn't that true?
Yes.
And you talked with you actually had an administrative hearing on all this back on April 13th of 2021. Do you remember that?
Yes.
Remember going down to the department?
Yeah.
Do you remember the excuses that you offered then as to why you weren't taking care of your business? Okay, I'm going to give you a fair opportunity to read the administrative findings here, sir, before I ask you some questions. You have a chance to read it?
Yeah.
So the excuses that you offered at the administrative hearing was all about COVID, right?
Yes,
That you hadn't been able to take care of your business that way, right? Specifically, it said you even had some testing that prevented you from even going to the administrative hearing. And prior to this administrative hearing, you'd actually only made one payment on your probation that you started in 2019. Correct?
yes,
And that you hadn't even done any community service hours. Those were the facts whenever we filed this first motion to revoke probation back in May of 2021. Yes?
yes,
Now, between that date and the date of December 22nd, you corrected a lot of that, didn't you?
yes, I paid all my fees, did community service hours. I also did the anger management class. All my fees were paid, court fees was paid, everything was paid.
Do you think that the anger management program worked for you, sir? It didn't, did it? Because you got mad by your own testimony today, back on May 21st of 23. Right? Yeah, we're not gonna mince words. You actually told Detective Terry Cater that you were responsible for breaking that window. And you've said that again today. You realize that's a criminal offense. It's criminal mischief. You've admitted to this judge today that you violated your probation. Maybe not in the way I've alleged, but you said you did it with your fist.
Yes,
Yes?
yes,
That's because you lost your cool. And basically listening to everything that you've said, sir, you and Miss Clayton have said the same thing about what happened with one big detail missing. You're not admitting to being in possession of a gun that day, are
not permitting to be in possession of them because I wasn't in possession of them.
you?
At
Right.
all.
That's the difference between y'all's story. Your version and hers is whether or not there was a gun there. Right?
Yes,
But you heard her testimony. She says that's what happened. Now, you just admitted, again, and I clarified that you violated the law, sir. You broke somebody else's property.
Well, Your Honor, I'm going to object because if they're married and the car is community property, 50% of the car is his and 50% is hers. So it could not be criminal mischief. He wasn't charged with criminal mischief.
Well, he was, it is alleged that he's committed the offense of aggravated assault with a deadly weapon.
That's
Yes,
correct. Judge.
And also I'm sorry, there are these things. Also, within that, he could also be, it seems to have been proven here that the lesser included offense of assault, if it's not a deadly weapon with his fist, certainly meets the elements of that offense as well as a lesser included under assault. But the point is, it's the reading of the record that I have it right now is he's admitting to an offense,
So take a look at state.
which is a violation, which would be a violation of,
The offense is not criminal mischief.
it may or may not be, it hasn't been proven otherwise. It hasn't been proven yet that it meets the elements of criminal mischief. There was damage to property that she was operating in the motor vehicle, but nonetheless, the gravamen of this offense that concerns this court is assault.
State's exhibits 1 and 2. Whose car is that? That's your wife's car. Speak up. You didn't have a problem
yeah,
earlier.
that's my wife's car.
And she was the one driving this vehicle that day, correct?
Yes,
State's exhibits 3 and 4, the damage that is shown on that vehicle. You caused that damage. Again, you're being kind of soft spoken. That's a
yes,
fact,
yes,
right?
that's a fact.
You're saying that it was done with your fist.
Yes,
You heard your wife testify that she was placed in fear. Well, don't you think that's at least a natural reaction to somebody breaking your window like that? Fear? Fear of what other damage can be done? You don't want to answer that because you know what the result is, right? That's a natural response. Mr. Clayton.
natural response.
Yes, sir. So you so freely admit that you've had so much contact with Ms. Clayton despite the judge's rules. She is the complainant in this probation, is she not?
She is a complainant. Me and my wife have had contact with each other even before I was arrested to even go to jail.
Thank you for volunteering, sir. The answer is that she is the complainant. She was the person who had to seek a protective order against you, and that resulted in you being placed on felony probation for violating that protective order.
Yes, that's correct.
That's the same, that's one and the same person, right?
Yes,
And you are aware that one of the conditions of your probation is that you're not supposed to have contact with her.
when I came in here, Ralph Kimball was my lawyer. They stated that he stated that me and my wife was living together the day that I signed for probation. And a protection order was lifted.
Okay.
That never was a condition of my probation, how me and her was living in the same,
You're familiar with how the system works, right?
yes, sir.
You're not supposed to be having contact with victims. You understand that, right?
Yes, I understand that. That's why we
You-
made it stated in the same court.
Okay, so let's move forward. You end up going to jail and you know you're not supposed to have contact with him, correct?
Yes.
So records indicate that you emailed her some 70 different times while you've been in custody. Do you agree or disagree?
I disagree.
So you've not had any contact with her by email.
Before I came in here to court, me and my wife have had contact with each other. I even have emails from her telling me to call her.
Have you yourself emailed Miss Clayton, the victim on this matter, sir?
Yes,
Have you done that while you've been in custody
yes,
with full knowledge that that violates the rules of how this court operates?
yes.
You understand what that means, right?
I understand.
Do you disagree with my number when I tell you that the records reflected some 70 different times? No, I'll tell you, sir, you're not answering me, and I'm gonna tell you anyway, that the records do reflect that she emailed you back 10 times. So out of the 80 different emails that we found between the two of you, you sent her 70, she sent you 10.
We also talked on the phone. There's also been emails.
You realize that's another violation, sir, which you're just admitting that I didn't even ask you. You want to talk to your lawyer before you go further?
Yes,
Let me ask you, let's be specific here. It certainly is a bond condition. That's in the bond conditions. He's not on bond.
But I had him admit before I went into that he knows that the rules say that you're not supposed to be contacting victims.
Well, if it's not a bond condition, I don't, I think that it could be investigated as attempting to pressure a witness to a criminal act and trying to influence testimony, but generally the bond conditions, people on bond have, it's strict. That's what the rules are by all, those are the general rules of the court that we have in our posted conditions of bond, but we're not talking bond here. But I'm more concerned about something other than that. I'm more concerned about the hostility and the threats to that lady. I understand people I think we may have a different opinion about what love is and attraction but what we shouldn't have a difference of opinion in, and that is treating somebody decently, but most importantly, lawfully.
Yes, sir.
Even if they're
So
husband and wife, but or a relationship of a mutual interest of romance. But here is the problem. It's you violated a bond protective order that got you this probation in the first place. That's what bothers me. You've been on probation a few times and failed probations. You've had them revoked 1, 2, 3 times. It just seems like the rules are difficult for you to follow because, like in this situation here, what I'm observing is you want to be in control of the situation. But remember, she's sitting in the driver's seat. This is kind of dangerous to break a window at the driver. It's glass. And to this, you don't see this much because people don't do this. This is very destructive behavior. And when somebody's in the driver's seat, that's certainly most assaultive. Somebody's going to get risks severe injury. But let's wrap up.
yes, sir. Last thing I want to ask about your contact with Ms. Clayton. Did you in fact ask her to sign an affidavit of non-prosecution? That's a yes or no, sir.
yes, I did, because when this first kicked off, she asked me what did I need to do. I said, well, I didn't have a gun. I never had a gun. I've been admitting that since the beginning of this case.
And that then coincide with her providing funds for you and communicating further with you?
When I first was, when I first was arrested, when they took my car from me and the keys to my house, they released them to her. She the one who's been taking care of my car, my house, paying bills when the kids needed school clothes.
Do you know where she's living now?
She lives at 16,
Living at your house?
apartment 216. Now my brother's living there now. But when this first kicked off, she was doing basically everything. She was taking money. I released money to her from the county jail. Actually, over $2,000, $600 for school clothes for the kids. She had some tickets she needed paid. That was $475. She sent e-coms, and it wasn't because from what she said that I was harassing her, telling her why this and that. I say, well, go ahead and send me an e-com, so I could have some food. Obviously, even though I had money on my books, she still sent e-coms.
So
I never
you
harassed her.
released everything, when you went back into jail this summer, you released everything back to her?
I released, actually, I just not on my property, on my phone, so my clothes ain't in it, but I did release actual funds off of my accounts
And gave her access to your house and your vehicle?
and my bills.
Anything that the court would like to ask, Mr. Clayton, Judge? So, we've both sides.
No additional questions.
Okay. You can have a seat. The complainant in this case, this lady, does the state have any information of criminal history concerning this lady?
I'm unaware of any, but I want to do another check just to be certain, Judge. I'm pulling it up as fast as I move. Our records only indicate her as a victim, Judge. I did hear another name. I'm going to double check that other last name.
Okay, thank you.
And Mr. Boyd has done that, and that matter, it was a misdemeanor assault that was filed in 2018. It was dismissed.
What about you, sir? How about your convictions? How many do you have? Before I tell you the answer, you should know it's your life. How many? Let's start off with the felonies. How many felonies? What about, and let's see, that's theft. You were placed on deferred or unadjudicated probation. That's in Angelina County. That was revoked. And you received 10 months in state jail for that. So that must have been a state jail. But then there's a burglary of habitation. In 07, you were placed on 6 years deferred or unadjudicated probation, and that was revoked in 2012. You received 11 years in prison, correct?
Yes, sir.
Oh. What about misdemeanors? How many misdemeanors? I'm not talking class Cs. That's speeding ticket. I'm talking, or a fine only class C. I'm talking about courts of record. 10. Trespass, criminal mischief. Criminal mischief twice. Protective order violation in 17. That's not this, it's, then we have, that's a misdemeanor, protective order. Then you have this indictment in 2018. Yeah, it just says 2017, he received 180 days in jail for a protective order violation in 17. So. What do you want? State and then defense.
Judge, I want prison time. And the reason why I do is I want him to be revoked. She said it best. The only way that she's been provided peace is knowing that he's locked up. And his actions, even by his own words today, should result in that. Now, that separate and aside, I believe that the court should find the aggravated assault with a deadly weapon true. There's no reason not to believe what she has to say. She doesn't have any kind of criminal record. She doesn't have any situation to say that. And I just vouch, and I believe that she was credible in all regards. I think that what needs to be done, he's got anywhere from 2 to 10 years. I'm asking for 10 years.
Well, she does have a criminal record in 2017. He went down and dismissed the charge, Judge, when she was under another name. And I would probably tend to agree in reference to revocation and prison time, except for it is crazy. He objected to it. I guess he can't object to it now because I'm in closing. But you have somebody that says that I'm afraid of him. I'm afraid of him. And you've heard it many times, Judge. I'm afraid of him, but he releases the funds. They have communication. She knows he can't get out because he can't get out with no bond. But she still has communication. She's still providing money. She gets his car, she gets his house, she gets his keys. They still have a kid together. And she's still communicating. And even though it's against a court order in reference to being together and going outside the county, she's going to Las Vegas to Circus in June. And he gets picked up in July. And it's just crazy.
Yeah, but
They don't
that
need-
wasn't a violation of her probation order, was it?
But it
That was
goes,
his.
you're absolutely right.
That was his problem.
But it goes to, when the state says you gotta believe her,
What are you asking? for? I understand fully. Your whole questioning has been, you're pretty much an argument that I knew you would make, and I understand what your argument is. But what do you ask? What do you think is appropriate? Yeah,
I would ask for a continuation. The reason why is the court brought it up. The state now has entered into State's Exhibit number 5, with reference to the prior motion to revoke. He was told that he didn't do his community service hours, and this was during COVID and all the other things. He'd started doing his community service hours. He was told that he didn't do his moral recognition or recollection or whatever it is.
reclamation.
That's what I wanted to say, Judge. But he started with the anger management, which kind of coincides probably with another probation officer. You've heard from the probation officer that he's complied with what he had to say prior to the May 21st incident. Of course, as the state points out, the difference is that he claims he didn't have a firearm, that he did get upset, though it was community property. He shouldn't have done what he did. But it just doesn't make sense that she's in fear and says all these things, but you have communications even after this incident and spending time together and vacations together, and even in jail when she knows he's not getting out. But I don't know how you separate it. How do you separate it?
What about this? Something we see too often here. Especially in a home environment where you see 10 convictions, 12 convictions, and then nothing on the other side. How about an abusive relationship? Mental harassment. Someone who has testified today, she hasn't felt confident with the way the system works. It is a glitch. How do you deal with that? Especially someone who is going to punch out the window of a car with his fist, according to him, right where the driver is seated. I can appreciate and understand. She's not confident in her security. She's afraid. It makes sense. I feel sorry for her because I know him. I know of him. I've dealt with him here. He's a bully. He's been bullying her. And I'm the fact finder on this. And this is a fair representation of who does this. And you're trying to say, this is your property too?
So
It's not a dialogue. You had your chance. You're under this court's supervision, and you treat that person you're married to, that you should love and cherish and protect. You're talking to a guy who's been married 40 years. And I'm sorry, your version of a relationship is you're a controlling person over someone who really can't get in a position to protect herself. And she said, this takes too long. And you're someone who pulls this. Well, I can understand how she would have fear. And between those two diverging stories, I believe her. For the record, I believe her version. Not yours, hers. And this isn't the first time you've had, let's see, you were. Spent 180 days in 2017, 180 days in jail for a protective order, family violation, family protective order in 2017. I'm not clear what that is relating to. Then you have this case thereafter where you are indicted for an event that happens in 2018. So we have another protective order indictment charge that occurs after you are placed in 180 days for this. And so you're on this probation, and then while on this probation, God bless you, you do this. Now, let me come out with this, which is a legal issue. Because I think the assaultive behavior is the key. I've heard a little conflicting sides of the story about the moral recognition therapy. He attended anger management, I think, right? Completed that. That was a key thing. And moral recognition therapy has a lot to do with that. But it's then performing community service hours as required. I'm still a little fuzzy about that, and the least of the problem we have is we had probation officers changed in the middle of this, and it's not clear. The real problem is this, although at the end of the day, whether it's the punishment range is higher or low, this states that you are alleged to have committed aggravated assault with a deadly weapon, namely a firearm. Now, a couple of things. Beyond a reasonable doubt is not the standard, it's probable cause is the finding. I don't hear anything about a firearm. A firearm has a definition. Nobody produced a definition, prove that a firearm was used. This lady did say a gun, but nobody there's nothing in the record that fits the definition of firearm. Something that's capable of firing a projectile by the use of an explosive. But there is a lesser included offense under assault, as this is charged under 2201, 2201 of Texas Penal Code. A person commits an offense if the person intentionally or knowingly threatens another with imminent bodily injury, including the person's spouse. That's A, subpart 2201, subpart A, subpart 2. At the very least, that's what happened. At the very least. And it's a misdemeanor, but it's still assaultive. And he did this to somebody that while you are on probation for the violation of a protective order. That just seems like, Mr. Bully, you and your aggressive actions are your way only. And that lady that you're supposed to cherish and love is living in a hell of a relationship because you do this. That's thug. That's being a thug. That's not taking care of the lady that you're supposed to do. And that's if that's your version of love and cherishing and honoring, you've got the wrong dictionary. You're from another planet, not Earth. Because it's supposed to be peaceful in a family. It's supposed to, and this lady came across clearly threatened, fearful, and is not encouraged with the way the system works. And that's unfortunately the way the system can work. Because we can't get things, we can't go from here in a week from this event to a hearing in a week. We just can't do it. It takes too long. And yeah, going on a trip with you to Las Vegas or giving money, she explained that away. She's afraid and distrusts the system. So between who I believe, even if she did those things, I can understand her being under a coercive environment, a duress. She's fearful of you, then I can understand why. So I'm going to find that allegation 1 is proven true, whether it's assault with a deadly weapon, namely a firearm, or the lesser included assault, which is less serious of a crime, but it's nonetheless assaultive behavior. And it packs the same type of action that you're on probation for, a violation of a protective order. You're a bully, and the rules of peace and lawfulness don't follow you. You certainly don't follow them. And I find that by a preponderance of the evidence or greater. And the other two are close calls, but that's not going to drive this train. Driving the train is the criminal act, even if it's minor. So
Before
I
you-
find it enough to grant the motion to revoke probation.
Please, the court.
Yeah.
He would like to address the court.
Who?
Mr.
Okay, all right. You certainly had your fair chance, but if you want to say anything, go ahead.
First, I'd like to state for the situation that happened that day, I did take the anger management class.
How did that work? I think you failed.
I failed that day because I did let my emotions get the best of me.
Well, we taught you better.
Since November till we got evicted from the apartment, I've been sending $1,100 for my rent. The rent didn't get paid. I got emotional about where's the money going, we getting kicked out of here. I lost my cool.
Yeah.
And I did hit the window in the shadow. I did.
Where she was driving the vehicle.
Yes,
She was
yes.
driving. She's lucky. She didn't get hit by the glass and injured, but nobody does. That's an act of meanness
And
and hatred, sir. That's anger.
And with that,
Mr. Anger Management.
the same car that she had, that's the car that it's not neither here nor there, but
No, it's not.
I paid for the.
It shows what kind of person you are. And as your attorney pointed out, this is in front of everybody in a public place. Oh, you're showing that you mean business, that you're in control, that people should be afraid of you because you're a tough guy.
That wasn't.
And it's a girl.
That
It's you
wasn't
picking on a girl.
Mr. Stevenson, that wasn't my cause. The only thing I was upset about, if I've been.
Okay, so it's not your car. So you're damaging somebody else's property.
Not that. What I'm saying is, I've been paying all the bills, sending money, paying the insurance on.
You're not, sir. You can't pay your way out of misconduct.
I'm not saying.
You can't just write a check and everybody goes home happily. That's
Sir,
not the way, or otherwise rich people get out of jail for free.
I'm not saying that, Mr. Stevens. What I'm saying is, the reason why all of this even happened is because, again, I was paying sending this money. We get evicted from an apartment. The bills.
It's
being
not,
paid.
what you're saying is it's her fault, not yours.
No, it is my fault because I let my emotions get.
Okay, well, then you pay for that. You've got 12 convictions of courts of record, 12. Isn't it about time you quit letting your emotions drive you into the prison? Because that's where you're headed. And it's just not private. You're doing it out in public because you're not afraid. You're gonna show to everyone what your anger can do. And you got this lady scared to death. Your wife, the one you're quote love, she's scared to death and she's lucky she wasn't injured severely. And y'all have a child, right? Child, right? Yeah, yeah, well, I'm sorry, I'm sorry. That's another reason you shouldn't be acting that way. Did y'all have a child together when you broke the window? That's a question. Yeah, yeah, yeah.
I'm not making no excuse.
Well, let me ask you, what do you think your child, if the child was old enough to see that, the way you were treating her and the way you around the rest of the child's life, maybe? Because the child then has been confused because the child thought it was in an environment, the child was in an environment of peace and love, and that's completely on the other side of the coin from that. Right? The point being, you're supposed to be the head of the house, the role model. You set the example. You've been setting bad examples far too long, and you're continuing to set bad examples. And you can't write a check for that. You got to act like you're the example setter with good conduct. And love is not knocking the window out of the driver's side where the lady is sitting. That's endangering a child, endangering a person while you're on probation in this court. So the motion to revoke unadjudicated probation is granted. Now, what's state asking for?
I'm asking for 10 years, Judge. Trying to give this lady as much peace as I can.
And
It would be the opposite. Either low or.
see Mr. Burbank, you know, here at the pre-sentence report, he received 11 years in prison the last time. And you see, this is the third time on felony probation he has failed. And misdemeanor probations, at least one revocation. See the rules. I mean, we're talking about all the way from 2004. This is 20 years of failing to follow the rules of conduct. If nothing further, I'm going to find that, again, this motion to revoke unadjudicated probation is granted by a preponderance of the evidence or greater, as allegation 1 has been proven true in the motion. And if there's a question as to whether there's certainly the court can find whether it's his hand or something else, although it's alleged a firearm was used, but something fits the definition that's capable in it, the manner of its use, whether it's your fist or a firearm or some other or a gun that does not fit the definition of a firearm. It's still a deadly weapon was used because anything capable of breaking the glass like that is certainly capable of causing death or serious bodily injury. Because the glass is made by vehicles is supposed to be able to endure the elements of weather as well as road matters that fly off the road. But nonetheless, it does fit for certain the lesser included offense of a threatening action to cause bodily injury. Certainly when the circumstances are the glass breaks where she's in the driver's seat. I mean, it's just a foolish thing to do, no matter what you're using. But if it's just your hand, I mean, you just have a real anger management problem that we didn't solve by taking anger management. So your probation is revoked. Earlier in this case, you pleaded guilty voluntarily. You were mentally competent to do so. You understood the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt, and you are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 8 years. And that's the order of the court. Anything else? That is all.